That's what it was. It wasn't a DEP report, it was an environment. But Sandra asked me to come here tonight on a Friday night, which I normally refuse to do, but she's so persistent. She's a great lady, and I appreciate the opportunity to be here. To talk specifically about the whole local law situation. And so that's what I want to talk about, and I'll be happy to answer any other questions. And let me start off by saying I am a planner by profession, but I'm here tonight, I want to make it crystal clear. I represent Energy in Depth, which is an industry-sponsored organization, and that's who I speak for this evening. We do a lot of work promoting natural gas development in both New York and Pennsylvania in 21 different counties. I'm proud to do it and happy to be associated with them, and I don't want any misunderstandings. That's who I represent. I had written a little piece that if any of you didn't get a copy of it, there's extra copies up here, about this whole local law situation, because it's something I've had a lot of experience with. I've spent about 35 years of my life writing zoning laws in both Pennsylvania and New York. It's something I know a lot about. And I've written them for many communities, including this very one we're in tonight. I represented this community for 12 years or something like that. I've represented most of the communities in Sullivan County at one time or another. I've represented most of the communities in my home county and many in Delaware County and other places throughout New York, Pennsylvania, and some in New Jersey. The zoning is something that I've spent a lot of my life working on. And I see these ordinances, local laws, home rule laws, whatever you want to call them, being promoted by two different organizations, primarily one, but there's two that are promoting bans, essentially. Both supported by a group called the Park Foundation out of Ithaca, New York, which is a $315 million foundation that is proud to say that it has an army of anti-gas folks trying to stop shale gas development in New York. And they have committed many thousands of dollars, specifically in 2010, $50,000 to a group called the Community Environmental Defense Council out of Ithaca, New York. And that group has run around all of New York State. There's a similar group they're funding in Pennsylvania, which has a different approach, but doing essentially the same thing. And the one that's running around all of New York has been in Lumberland and several other communities out to Livingston County, everywhere. They are an organization that is primarily consists of two people, husband and wife, Helen and David Zlotchi, who are attorneys, and they are promoting a particular view on this local law, which I don't think is correct. And I think any community that is listening to what they have to say about this should carefully consider who's paying. You know, it's not pro bono. It's only free to the community because somebody else is paying for it. I don't think you would like it if I came into any town and said, here's a zoning law for you, and I'm representing Energy in Depth. It's free to you. It's free to you. So I would ask everybody to be very cautious about that. Now let's get into the meat, however, of what they say, because that's really the important thing. This is not exciting stuff. I apologize for being boring in advance, but it's important stuff, because there's a lot of talk about it, and a lot of people are making decisions based on the recommendations of these two people, and I don't believe they're correct. Now maybe I'll be proven wrong. That's fine. None of us really know the answer until we get to the end of the road with an appeals court decision. But I'm pretty sure where it'll go, and we'll see. We'll see. First of all, I want to point out that the entire argument that the Zlotchis make, and I don't want to talk about Bethel specifically because I have a lot of affection for this town, and I don't really know the specifics of everything that's being proposed here, and I don't want to question anybody's motives here. I want to focus on what is generally being proposed by the CEDC throughout New York State. And everything that they propose really rests on a couple of key assumptions. One is that what has happened with respect to mining law, which has to do with removal of rock, sand, and gravel, and things of that nature, will also apply to oil and gas. Now there are two sections of the same law, the environmental conservation law, that apply. One is what we refer to as the mining law, which is I forget the exact section number, but that's a particular section. And then there's another section which we commonly refer to as the oil and gas solutions law, I believe. We'll just call it oil and gas. And that's another section of the environmental conservation law. The Slotskys are essentially saying to everybody, look at what happened with the mining law, part of the environmental conservation law, and let's apply that to the oil and gas law. That's the first big assumption they make. And there's some problems with that, because the mining law has changed over the course of time. It's not the same as it was back in the 1980s when the first case was decided that they rely upon. It changed. The second case that they rely upon occurred after the law had been changed, and I'll go through that in a moment. But that's very key, because when they mix up these cases, they don't tell you, unless you read very carefully, that one of them occurred after the law had been amended to specifically allow towns to do zoning of the type that they are proposing. That does not exist in the oil and gas law. It does not exist. The law itself says, and there's a couple of provisions here, it says, I'm going to read it, it's kind of boring, but in the mining law, it says, this is for the law back in 1991, or prior to 1991. The mining law then said, for the purposes stated herein, this title shall supersede all other state and local laws relating to the extractive mining industry, provided, however, that nothing in this title shall be construed to prevent any local government from enacting local zoning ordinances or other local laws which impose stricter mine land reclamation standards or requirements than those found herein. Now take notice, it specifically mentions zoning. Now, let's listen to what the gas law, oil and gas law, said prior to 1991 and still says today. The provisions of this article shall supersede all local laws and ordinances relating to the regulation of oil, gas, and solution mining industries, but shall not supersede local government jurisdiction over local roads or the rights of local governments under the real property tax law. Two very specific things, roads and taxes. The word zoning doesn't appear there. Does not appear there. Now, that's a key distinction right there. The fact that the two provisions, one has an exception that specifically deals with zoning, and the other has an exception that specifically deals with roads and taxes. That's a big difference. It's a huge difference. I would also point out that the zoning qualification that was in the mining law, when it was addressed by the New York State Court of Appeals, they noted that the standards relating to reclamation were in there, and they added that in the absence of any indication the statute had such a purpose, which would be to restrict zoning, such an interpretation should be avoided. Now, what's important is that the oil and gas law specifically does provide an indication. It says very narrowly what can be done. It doesn't mention zoning. It says that what you can do is you can do roads and taxes. It's a much narrower range of activities. So this is a very crucial distinction. You know, we have lawyers who are promoting this idea, the Slotskys being two in particular, but there are a few others, who are saying, well, the language is very similar, almost identical, but they're only talking about the first part of the phrase. They're not talking about the exceptions. They're only talking about the initial clause, not the exceptions. And the exceptions are where the rule is made in this particular case. Now, the CEDC goes on to talk about a particular case called the Frew Run case. And this was decided 25 years ago. And it said in that case, it's very important, that it talks about prohibiting mining in a given zone. And it talks about a particular zoning district. Well, this is very important too, because that's not a ban. That's not a ban. The law that they're referring to, the original mining language, did not talk about, and as it was interpreted by the Court of Appeals, did not involve a ban. It involved zoning with respect to a particular zoning district. Very key. Now what happens is the CEDC tries to take this case that was decided 25 years ago, and then they try to mix it up with a case from 1996 after the law had been changed. They just cleverly move from one case to the next case, and people lose sight of the fact the law changed greatly in between those two cases. And if you look at it, you'll see the new language in the mining law says, this title shall supersede all other state laws and local laws relating to the extractive mining industry, provided, however, that nothing in this title shall be construed to prevent any local government from enacting or enforcing local zoning ordinances or laws which determine permissible uses in zoning districts. So, well, no kidding. The law changed. It specifically, in the mining case, allows towns to deal with zoning matters. Crystal clear. There's no surprise that the court is saying you can do that with mining. It says it. It was amended in 1996 to allow it. But that's not the relevant statute, because that's not the one that's being compared to the oil and gas law, and that's not the one the Slotskys are relying upon to make their case that you can do a ban because of the similarity of language. It's the old law, and the old law doesn't give that specific authority. It does reference zoning, but it doesn't give that specific authority. So, what you have here is a situation where the state, in the latest mining decision that they refer to, has specifically carved out an exception that allows, theoretically, what the Slotskys say you can do. But it's for mining. It's not for oil and gas. It's not for oil and gas. That's the key. And what's significant is that when the state, most significant, is that when the state amended the law for mining to say you can specifically address zoning of mines, you can specifically do that as an exception. It did not, in the very same law, the environmental conservation law, it did not do that for oil and gas. Now, it intended to apply the same principles from mining to oil and gas, and they're in the same general law. Don't you think the legislature would have amended both of them? It didn't. The next thing I want to point out here is the CEDC claims there's no case law that's on record that deals specifically with oil and gas. Well, there is one. It's an old one, like the case, the mining one that they refer to, going way back. And it's a case that was decided in 1982. It does involve zoning. It's a somewhat unusual zoning ordinance, but it is a zoning ordinance. Slotskys dismiss it by saying, well, it's styled as a zoning ordinance, but its title is zoning ordinance. Okay? That's its title. And what the court found in that case, the Erie County Court, they said that the oil and gas law expressly preempts not only inconsistent local legislation, but also any municipal law which purports to regulate oil and gas well drilling operations, unless the law relates to local roads or real taxes which are specifically excluded by the amendment. And they went on to say that the town could not broaden that at its will. And that's really what the Slotskys are asking everybody to do. They're asking everybody to rely upon a 25-year-old case relating to a law which no longer exists, which has been greatly amended, and to broaden it at will to say we're going to outlaw natural gas development. And if you look at one of the other laws that's been enacted, Town of Lumberlands, you'll see that it includes no less than 21 definitions, which are clearly intended to segregate natural gas development as a use and treat it differently than other uses. They go into definitions of exploration, gathering line, high frequency, high impact truck traffic, injection well, sequestering water use, underground injection, underground natural gas storage. It's clear what they're doing. They're trying to regulate that specific industry. No less than 17 of the 22 uses that they prohibit in that law relate to natural gas in some way. And they've also gone to the point of changing some of the state rules indirectly by, for example, raising the threshold level for water use from 80,000 gallons per day to 100,000 gallons per day in terms of what's large-scale water use. And they've simultaneously exempted much larger uses of water, such as agriculture and recreation, such as golf courses. So there's no doubt in my mind that they are venturing into a prohibited area. It's not just use that they're regulating, it's the specifics, and it's targeted at natural gas, and they don't apply the same standards to other similar uses. There's another practical problem that I think most of you will relate to, and that is the fact that mining is not drilling. It's not the same. There are big differences. For example, if you look at the authorization for the law, you'll see that the authorization, or the purposes, I should say, the policy the state enacts with respect to mining goes into things such as declaring it's a policy of the state to foster and encourage development of economically sound and stable mining, orderly development, addressing economic needs, compatible with sound environmental practice, and it declares to be the policy of the state to provide for management and planning of these non-renewable natural resources and to provide for reclamation, etc. Now, those are kind of general, motherhood and apple pie types of things saying, look, we recognize mining is important, therefore we're going to provide for it, we're going to balance the economy and the environment, and all will be well. The oil and gas law is much, much more specific. It says it's declared to be in the public interest to regulate the development, production, and utilization of natural resources for oil and gas in such manner as will prevent waste, and in such manner that a greater ultimate recovery of oil and gas may be had, and that correlative rights of all owners and the rights of all persons, including landowners and the general public, may be fully protected. Very specific language that gets at objectives that go far beyond simply balancing the economy and the environment. It deals with how you recover this resource, how you do it, and how the rights of different people are balanced specifically. And it then goes on to get into some other things related to that. Now, for example, I would like to note that if you look at the differences in the language between these two, the oil and gas law sets out three very specific objectives that are not addressed in the mining. And all three of these have to do with something called the integration and unitization in oil and natural gas pools. Now, that's really a recognition that oil and gas are not found in small pockets like sand and gravel is, or like bluestone is found, or other types of rock and aggregate. Those kinds of things are found in specific locations. We all know that. They aren't found under the entire town. You won't find sand and gravel everywhere in Bethel. You won't find bluestone everywhere in Fremont. You won't find aggregate everywhere in any town. You'll only find it in certain spots where it's economic to recover. Oil and gas, however, gas may well be under the entire town. And that makes a huge difference because it's a much, much bigger area and it extends beyond one town into other towns. And that means that's one of the reasons why the state is being very specific here is you can't have one town saying, we're going to allow it, and another town saying, we're not, when in fact the resource is under both, and one landowner's rights are going to develop within that unit are affected by what happens in the next door town. That's what the correlation is about. And that's why New York State, whether you like it or not, and I'm not here to take a position on this, but New York State has forced pooling. And that's why they have it, because they want to make sure the rights are correlated, they want to make sure there was no waste, and so on and so forth. So this is why they've crafted these provisions for compulsory integration or forced pooling. They've done it to address these specific problems. And that's why the oil and gas law doesn't allow the same kinds of exceptions that you might find for mining law. It's a very practical reason. There's also some other differences, which I think are obvious to people. One is mining is a permanent use. You go in and build a quarry, it may be there for 100 years, and when it's done, there isn't anything that's going to be done when it's done that looks like it was when it started. With gas, you're going to find much that is the same, and in fact, it's not a permanent use, it's a temporary use. And you can go to, they showed some scenes on here, and I've been to sites, I've been to many sites where there's many farms where there's gas wells in the past, and There's farming going on all around it. The farm is still the primary use. It's not the gas well. The gas well is an accessory ancillary activity. It's a temporary activity. That's not the case with quarrying. The quarrying is a permanent activity. And there are a number of other things along that nature. But what it all really boils down to is that what these natural gas bans about is really an ideological cause. It's not about the legality for the CEDC. This is an ideological cause for them. And they are being paid, just like I'm being paid. They're being paid, but I'm not here to offer the town of Bethel my free advice about how to write a law that's going to benefit my interest. I'm not doing that. The CEDC is trying to do that. And that's the problem. And I think any town that acts on that advice is very ill-advised, because it's a recipe for disaster. It's relying upon somebody that has a special interest to essentially guide the policy of the town. Now, is it wrong for the town to listen to them, hear their opinion, take it into consideration, judge it with all the other opinions, including mine or whoever else? Sure, fine. But to rely upon them and say, well, we're going to take this free legal advice because it's been offered to us, when in fact it's on behalf of a special interest, I think is extremely foolhardy. And I don't think this thing will survive the test of the courts. So that's my opinion.